Let's talk about asset protection for your crypto, protecting it from creditors, lawsuits, and divorce. If a judge, a creditor, or an aggressive plaintiff learned where your Bitcoin lives tomorrow, could they make it disappear from your hands within a week? If your answer isn't a confident no, stick around because the difference between panic and peace often comes down to legal structure, timing, and smart custody. I'm the business guy, the CEO of the Lawyers Limited Law Firm and Asset Protection Planners. I've been protecting client wealth for decades, nearly 30 years setting up Cook Islands Trusts, and 34 years in asset protection overall. And in crypto, the rules are different. So welcome. This is what actually works. And if you want practical jurisdictional solutions, go to assetprotectionplanners.com. That's our asset protection specialty for our website. And subscribe now. We publish strategies you won't find in a forum thread. Now, here's why cryptocurrency needs purpose-built direction. Crypto's different. It's portable, but that portability is really a double-edged sword. Sure, it's pseudonymous, but on-chain analytics and subpoenas make accounts traceable. It's liquid, but liquidity attracts attention. When a court issues a turnover order, judges don't just look at ownership. They ask one simple question: who has the practical control? And if you can move coins with a single signature, courts can compel you to do so. And if you refuse, you risk contempt, fines, and even worse. We see this repeatedly in practice. Business owners and professionals who self-custody large balances attract discovery requests, subpoenas to exchanges, and aggressive litigation. And without a structure that separates legal title, beneficial interest, and signing authority, those coins are vulnerable. Now, I'll later walk you through a composite real case where a single hardware wallet in an office lost millions and how a properly nested offshore trust would have stopped that outcome cold. Now, here's how creditors reach crypto in practice. People think, oh, it's crypto, nobody can find it. Well, that's not the case. Creditors begin with discovery. They seek accounts, wallet lists, device inventories, and transaction histories. They'll ask for seed phrases and device backups. And courts can order you to sign transactions or hand over private keys if you have present ability to comply. Now, we've seen clients claim lost seed phrase only to have device backups, cloud snapshots, or an employee's laptop tell a different story. We've also seen people move coins into a relative's wallet and still be sanctioned because the court found practical control remained with the debtor, or they simply sue the family member. Practical control is the killer metric. A judge doesn't need your technology to own the coins. They simply need to see whether you could move it quickly. And if the answer is yes, turnover relief and contempt powers follow. So an actionable point here: treat discovery like an audit you might face tomorrow. So don't change the record after a demand letter arrives. That creates the badges of fraud that could get you in big trouble. Okay, here's the core legal architecture that works. If you want durable protection, design that separates three things: legal title, beneficial interest, and signing authority. In fact, our preferred high security architecture tools like this. Top layer, Offshore Asset Protection Trust. For example, the Cook Islands. The trust owns the next layer, and it's administered by an independent licensed bonded trustee law firm located offshore. That's the trust company up here. The trust deed restricts unilateral removal or replacement in ordinary circumstances. Middle layer, the manager-managed LLCs. It's inside the trust here. So the trust owns the LLC, and you are the initial manager. So the LLC here inside the trust owns the exchange accounts and wallets. Now, the client may be the manager for day-to-day policy direction, but the operating documents limit unilateral signing powers. The bottom layer is the custody and multi-sig technical control uses of 2 to 3 multi-signature model. One key is held by the independent trustee up here, one by a professional custodian or protector, and one by you, the client. So no single signer can move assets alone. So why this matters? A U.S. court cannot easily force an offshore trustee to act if the trustee, law, and deed give them discretion. So contempt leverage is greatly reduced when you, the client, genuinely lack unilateral control. Here's a few important drafting points. The trust deed must limit your ability to demand immediate distributions or remove the trustee at will. The LLC operating agreement must reflect the trust role and contain clear delegation and emergency response rules. So you can change the trustee when the court isn't forcing you to. So if you want a different trustee, you can assign the trustee as long as you're not being forced to by a court. Multisig keys must be held by identifiable independent signers. Document who they are, where the keys are, and the signing policy. Now, I'll share some real-world composites showing how multisig and offshore trust stopped a turnover motion in its tracks. So I'll give you a real-life example, but only because the paperwork and the wallet registry lined up. Okay, now here are the custody choices. You can hold the coins in exchanges. You can hold them in hardware wallets. Or you can hold them in by multisig. Now, there's no perfect custody choice, only trade-offs. Exchanges are convenient. They support trading, liquidity, and margin use, but exchanges are subpoena magnets. If your account is in your name, a turnover order or bank-style freezes, they're trivial for a court to pursue. Large balances on exchanges are a red flag. Hardware wallets reduce exchange exposure, but increase contempt risk if you alone hold the private keys. Storing a hardware wallet in a desk or safe while saying it's owned by the trust is a control problem courts will see right through. So that's why multisig, in this case, is the best technical match for legal design. A 2 of 3 multisig aligning trustee plus custodian plus client mirrors the separation layers achieved on paper. So you don't want to be you and somebody else only. You want there to be 2 different third parties. So if the judge freezes your hand from taking the funds out, you can still get your money out when you want it. And again, these are trusted, regulated, insured, bonded individuals who have your keys and who can protect you when the seas get stormy. If the trustee controls one signer and truly cannot be compelled, you've created technical separation and legal separation. Operationally, map addresses to entity owners in writing. The on-chain record must match the legal record. Maintain wallet history, addresses, IDs, who can sign which transactions and under what policy. So keep this updated and stored with governance record. Now for exchange use, keep only the trading float on platform accounts. Everything else is in cold multisig storage. Let me give you an actionable checklist of what to do. It's short. The title accounts to the LLC trust where possible. So have the account held in the offshore LLC's name that's inside of your offshore trust. Deploy multisig that reflects the legal structure. Keep wallet and signing policies in written governance files. Rehearse an instant response. So if something bad happens, you'll know exactly what to do, who signs, who produces documents, who talks to counsel. A cliffhanger a little bit later, I'll outline the exact language that we use in trust deeds and LLC agreements to reduce the presentability findings. Okay, timing, fraudulent transfer law, and the look-back problem. So timing is really everything. Asset protection must be established before any claim. That'll give you the best protection. Transfers after demand letters or lawsuit risk can increase the heat for you in the courtroom. Courts look for badges of fraud, insider transfers, intentional concealment, transfers to insiders, continued control, and timing relative to litigation. Keep in mind, it's your opponent's attorney's job to get the money out of your backside. So they're going to do everything they can, make arguments to the judge. These factors that we're talking about here can extend the look-back exposure and create personal liability. Some states measure look-back periods in years. Offshore jurisdictions add complexity, but aren't magic shields if the transfer is clearly fraudulent. So here's how we mitigate timing risk. Document legitimate non-creditor reasons for the structure. Asset management. So in other words, some reasons for doing this look better than asset protection. You did it for asset management purposes. You did it for succession planning. You did it for centralized custody, tax compliance, and operational efficiency. So you can give other reasons beside asset protection for doing these things, even if asset protection is one of the reasons. Keep your governance records, trustee meeting minutes, distribution policies, wallet maps, and regular reporting. So treat the trust and LLC like a real functioning business, not a mailbox you use when litigation threatens. So never move assets after a known claim without legal counsel and a clear, documented, legitimate reason. In fact, the attorneys on our staff can help you with this. Example, here's a composite. A client moved crypto into an offshore trust 3 months after receiving a demand letter. The court reversed the transfer, ruled it fraudulent, and sanction the client. The key failure? No contemporaneous business reason and continued practical control. Okay, now here's tax and compliance. Now you still report everything. This isn't a tax dodge. Asset protection doesn't change tax reality. U.S. taxpayers must continue to report gains, losses, forks, airdrops, staking income, every taxable event. Offshore structures are drafted as grantor trusts or disregarded entities for tax purposes. So reporting flows through to the client's tax return. So you must coordinate this with a CPA. So maintain basis logs, that means what you paid for it originally, transaction histories, and a compliant approach to foreign account reporting. Now assume every transfer will be scrutinized under oath and organize records accordingly. So here's an actionable point to help you protect your cryptocurrency. Involve your tax advisor early when you design a custody and trust solution to the structure, and they're both protective and tax compliant. So here's a practical checklist I want to give to you. We implement this for clients, and this is the playbook we use. Title exchange accounts and wallets to the LLC trust and update your know your client information. So again, you're going to hold your crypto wallet inside this offshore LLC. And that's the name it's going to be held in. It's inside your offshore trust. That's what gives it the protection. Next, use of 2 of 3 multi-sigs where independent trustee or nominee is a signature. Keep written wallet maps and signing policies aligned with the trust and LLC agreements. Separate roles. Client proposes, entity executes under documented authority. So when you ask for the money, the other parties send you the money, unless a judge is compelling you to give it to somebody who's your opponent. So never move assets after a demand letter or litigation threat without consulting legal counsel. Now you want to document legitimate non-creditor reasons for this structure. I'm giving you a checklist here, so you want to write this down. Rehearse instant response. Who produces documents, who signs, and how to comply with lawful orders. If you follow this checklist, you dramatically reduce both legal and practical control findings. So when you get the flashlight in your face by the opposing attorney in front of the judge, you'll be sitting pretty. Now, here's mistakes we often see. Common errors that will kill protection are these. First of all, hardware a wallet in your own personal name, or just sitting in your desk on a thumb drive while claiming the trust owns it. Courts call that control. And that is also, if you say something that isn't true, you'll be held liable, you'll be in contempt. So if you say something that isn't true, that's perjury. You can be locked up for that. So make sure to tell the truth. Moving coins through mixers after a claim. That looks like concealment. Bad idea. Putting wallets in a spouse's name without changing control dynamics. Marital control traces back. Parking everything on an exchange in your personal name. Simple for you, but also simple for creditors. So these mistakes share one feature. They leave a paper trail or practical ability that'll let a judge say, you can move the coins now. When that happens, legal protection collapses. So in a minute, I'll give you a short script that you can use to present your wallet registry to counsel. So cultivate this now, not later. Okay, can a court force you to hand over your seed phrase? And the answer is yes. If you have the present ability, courts can order you to produce seed phrases or sign transactions. The risk is highest when you retain single signer authority or a recovery pathway that you can personally invoke. If your structure requires multiple independent signers, the trustee cannot be compelled because of foreign law and deed protections. Keep in mind, you may think, oh, this 75-year-old judge won't even understand crypto. I can fool them. Don't believe it. They can see right through it because the attorney that's being hired to get your money is very well versed in crypto, most likely, and also can make it very, very simple for the judge to understand whether you have control or not. So don't think you can fool it. Don't think you can hide it on cold storage. All these silly things that people think they can do that we've seen penetrated with a forensic audit. And the reason why we use the offshore trust is because the trustee cannot be compelled because of a foreign law and because of the deed protection. The court's ability to force their action diminishes. And that's the objective. Remove present ability, not secrecy. Here's a practical tip. Document who can sign, under what conditions, and where the keys are held. Don't create secret recovery methods that you alone control, because they'll be able to see right through that. Okay, let's talk about onshore versus offshore protection. So why offshore often wins for high-risk profiles. Onshore solutions can be effective, like onshore trusts and domestic trusts, for lower risk profiles. Domestic LLCs with genuine third-party signers, strong domestic trust statutes in certain states, and careful governance can work in some cases until a determined results-oriented judge decides otherwise. A U.S. judge has powerful contempt tools. A domestic manager or trustee reachable by subpoena enforcement is vulnerable. In contrast, a well-drafted offshore trust, Cook Islands, Belize, Nevis, trusts that we set up for clients every day of the week, depending on the facts, can raise jurisdictional enforcement barriers. Foreign trustees, local law hurdles, and the difficulty of enforcing U.S. contempt orders overseas. That doesn't mean offshore is always necessary. For modest exposure, say $100,000 or $200,000 or less, domestic shared control solutions may be sufficient. For high-stakes business owners with visible assets, offshore is often decisive. In fact, our work with high net worth clients led us to prioritize offshore trusts paired with manager-managed LLCs and technical multi-sig custody, because the combination creates legal, practical, and technical separation. Okay, here's a composite case study that we've anonymized. Here's the composite case client A, a U.S. entrepreneur with crypto positions, as well as several rental properties. Client A originally kept all assets in personal wallets and exchange accounts. After a business dispute turned litigious, the plaintiff served discovery to a turnover motion. Client A tried to move coins into a family member's wallet and then to an offshore address. The court reversed the transfers, found badges of fraud, and sanctioned client A. They also sued the family member. Contrast client B, a similar profile with 2 years earlier, they placed the crypto into a Cook Islands trust owning a Cook Islands LLC. The trust deed limited unilateral removal and gave the trustee clear discretion. A 2 of 3 multi-sig account was used. Trustee, the custodian or protector, and the client. When the plaintiff sought turnover, the court found client B lacked present ability to move the coins. The trustee refused to act without following local procedures, and the U.S. contempt threat had no practical bite in the Cook Islands. The plaintiff's motion failed, and our client kept their money. Here's a lesson. Timing and genuine separation really matter. Paperwork without operational separation fails every time, or most of the time. Operational separation without legal structure fails. Both together create durable protection. Okay, what should you do this week? Here's your action plan. If you hold meaningful crypto, do these 3 things this week. First of all, inventory and map. Create a wallet registry, addresses, balance, custody method, who can sign, where the keys or backups live. Give this to counsel under privilege cover. Next, pause movements. Don't move large balances after any hit of a claim. Moving coins after a demand letter creates fraud indicators. Call counsel. If you've not structured protection, consult us and we can help you get this all set up so you're protected with offshore trust, multi-sig, and a crypto custody. And it's something that you want to do now instead of later. Asset protection is a preventative game. So if you want our team to review your structure and you're serious and not just curious, and you have $500,000 or more in assets, go to assetprotectionplanners.com and request a secure review. In fact, we've set up more Cook Islands trusts than any firm in the world, and nearly 3 decades of experience informs how we design these nested structures. Here's a final thought. Cryptocurrency brings unprecedented opportunity and new vulnerability as well, especially when you're getting sued. The question isn't whether coins are traceable or taxable. They are. But whether your legal and technical design denies the court a practical ability to take them away from you when trouble hits. For high net worth owners, the most reliable pattern is a layered approach. Offshore trustee plus manager-managed LLC. Multi-sig custody, rigorous governance, and tax compliance. Used together, these elements change the legal calculus in turnover fights. So go ahead and subscribe for more legal strategies that you can actually use. I'm the business guy with Lawyers Limited and Asset Protection Planners. We design peace of mind for people who can't afford to guess.